So we're gonna get started. Welcome everyone. There's a bunch of people in the room, and they tell me that there's 150 more of you on the webinar. So hello to everybody on the webinar. I believe that if you have questions here in the room, raise your hand. We'll take questions as we go along, and we also have time for questions at the end. On the webinar, there's apparently some technological thing I don't know how to do, which is ask questions on a webinar, and those questions go into our assistant, and she sends them to me. So I don't have, my computer isn't doing its things, which is probably just as well. But we will get the questions, so if you're listening to the webinar and you have questions, use the function that allows you to do that, and those questions will get to us. So welcome, everyone. My name is Juliana Reno. And to my left is Tora Johnson, to her left is Harry Atlas, and to his left is Lisa Tavares. We're your speakers for today. We have other people that we work with, too, that are not speakers for today, and I want to give them their due. So we have here in the D.C. office Carol Calhoun and Greg Matisoff and Ken Hoffman. And then we also have John Wilhelm and Scott Thompson and Greg Ossie. And Jacqueline Mohameda is adjunct. She doesn't spend all of her time doing employee benefits, but she helps a lot on this project, and so did Greg. So thanks to both of them for helping. We're going to get started we're going to start with the health plan stuff and then move on to the retirement plan stuff. And like I said, raise your hand if you have questions, and I'll try and work that in. I'm more or less the moderator for today. I focus mostly on health plans, as does Tora. So she's gonna do most of the heavy lifting, and I'm gonna help out. And then Harry and Lisa are gonna split the retirement plan stuff.
So yes, thank you everybody for coming to be with us today and joining us on the webinar. Again, my name is Tora Johnson, and I'll be working with Juliana more than she may realize on the health and welfare stuff of this conference today. So. Get started with an update on the individual mandate under the ACA. So as everybody knows, and I've already forgot to click.
No, it's not doing its thing.
Down.
There we go.
Yes, so as everybody may remember, under the ACA, most Americans were required to maintain individual coverage or pay a tax penalty. That is true today, but is rapidly changing and will no longer be the case as of January 1, 2019. And to give a little bit of context to the repeal, or what's known as the repeal of the individual mandate, we should go back to the summer of 2017 when there was an additional pass at a comprehensive repeal of the ACA, but that failed and moved on to tax reform. But as part of the tax bill, there was a provision that reduced the penalty for failing to maintain individual coverage to $0. So in effect, the individual mandate was actually repealed and is no longer in effect in 2019. One of the things that we have seen is that some of the states are considering implementing their own individual mandate. We know that the ACA largely borrowed on the state of Massachusetts' requirement to have coverage. New Jersey has actually recently adopted a requirement to have individual coverage. I know Maryland, and I usually work out of the Baltimore office, has considered it, so there may be a trend towards the states taking over that requirement. I will note, and Juliana thought this was too much of a detail to include in the presentation, but I can't help myself, because for folks who are working on their summary of benefits and coverage for 2019, there's still a provision, and Jacqueline loves this provision, that says there is a penalty for failing to maintain coverage, and the government hasn't told us to take that out yet. That's your minutia for the day.
Before we go?
Yep.
There's 20 attorneys general have brought suit arguing that because the individual mandate was repealed, the entire Affordable Care Act must fall. Legal experts do not give that suit much of a chance of succeeding, but no one is willing to say never because it's the Affordable Care Act. So that is, suit is in Texas. There has been argument in it. We haven't gotten a decision yet. All the reports from the argument were that the judge seemed very friendly towards the AGs, that is, to striking the whole Affordable Care Act. And by whole, I mean the whole thing. Like, the black lung provisions and the Indian Health Service provisions. Like, it was a 2,000-page law, only about 200 pages of which had to do with employer health insurance. So the AGs want to strike the whole thing. The Trump administration has taken the position that you shouldn't strike the whole thing, but you should strike the popular parts of it because they're intimately tied. By that I mean the pre-existing condition provisions and other sort of consumer safety mechanisms, I guess is the best way to say it. And their argument is that those are the only provisions that are intimately tied with the individual mandate. So I'm telling you this because even though you don't have to, and employers don't have to deal with the individual mandate that much, although it's definitely in the background for your employees, if the judge throws the whole thing out, that's going to be quite a shift for employers. I don't think it's going to happen, but, keep your ear tuned to that little lawsuit because it's going to be interesting.
So, switching over to the employer mandate, that has not been repealed. And in fact, we're seeing many of our clients and other employers receiving letters from the IRS assessing penalties for the 2015 year, right? We're in 2018, but they're working on the 2015 penalties. And it's a letter 226J. And if you haven't told your mailroom to send that immediately to you, you should. They should be on the lookout for them. We have been working on corrections to filing. So essentially you get this letter from the IRS that says, we believe you owe X thousands, millions in penalties. They give you an ability to submit additional information. We've had success in actually changing reporting positions because either there has been a mistake in software or we found additional documentation to support the corrections, submitted those, reduced penalties. But and our experience has been that the IRS hasn't actually pushed back to see that underlying material. They really have taken the employer at their word. And I don't know if you want to talk about the safe harbor transition rules and how that's been playing out.
Sure. So I had a client who in 2015 offered coverage to full-time employees, but not to dependents, right? And so in order to get protection, the general rule was you had to offer coverage to employees plus dependents. There was specific transition relief for 2015. So if you met conditions A, B, and C, like you already had your plan in place and you had never offered coverage for dependents and you were just working on it and you couldn't get it in place yet, that's not the technical terms, but that's the gist of it, then it was okay, right? It was okay if you didn't provide coverage for dependents. So when we reported for that client reported that the coverage was only for the employee. So they got hit with penalties for all of those because there was nowhere on the form to say, hey, we qualify for dependent transition relief. So when we got the form, we wrote back as part of our response to the IRS, we said, all of these people would qualify for transition relief. So you can ding us for other things, but not for that. And we just wrote it in the letter. We didn't provide supplemental documents to justify ourselves, and the IRS took that without a problem. So we didn't have to change the codes. We didn't have to correct it. We just had to say, we're entitled to transition relief. There was nowhere on the form to put that down. Here's our explanation. And the IRS said, you're good.
And there are theoretically on the books penalties for reporting failures, but we have not seen the IRS assess those penalties, nor have we heard about them being assessed in the marketplace.
Right. So to give the same client example, they had left off some safe harbor codes that they were entitled to. And when you get the letter from the IRS, it tells you it tells you the employees who had the premium tax credit, so who's essentially generating the penalties. And it says, if you want to correct any of the codes, here's a form to correct it on. So we corrected the codes, sent it in. They took all of that. Now, technically, if you sent an incorrect form to the IRS, then you can be hit with reporting penalties, right? So we corrected them, so that means that we sent incorrect forms previously to the IRS, or else we wouldn't be correcting them now. We haven't heard anything about that, anything about the reporting penalties, correction penalties, however you want to put it.
There is one argument, though, that they have not yet addressed, that under the Affordable Care Act, one of the prerequisites before a penalty could be assessed is that the employer got notice from the exchanges that they had employees who are eligible for the tax subsidies. The IRS has taken the position that their love letters, their 226J, are those notices, but that's from the IRS as opposed to the exchanges. And the whole point of those exchange notices were to give employers the information that their employees were qualifying for subsidies so that they could make game-changing rules during the year. So to provide 3 years later this notice doesn't seem to be in the spirit of the Affordable Care Act and what the thought behind the exchange notices was. But they have not yet formally taken a position, and so we're interested to see how that plays out. And then lastly, I would say on the employer mandate, there is legislation bumping along in the House that would actually suspend the employer mandate penalties from 2013, although it never really went into effect in 2013, they went into effect in 2014, through the end of 2018. It would also then change the definition of full-time employees. As you may remember, full-time employees is at 30 hours under the ACA currently. It would bump that to 40 hours, and it would alleviate the need to report on individual coverage since there is no longer an individual mandate unless an employee came to you and asked for it. But again, that's in the House. I think it passed the House. The Senate isn't expected to look at it until the end of the year. Juliana, using her crystal ball, says it will go nowhere.
Well, there was no appetite for it at all in the Senate. It passed a while ago, passed a couple months ago, and McConnell said he wasn't going to take it up. So I just don't think that they're too interested in doing that. We'll see if the House flips and the Senate doesn't. I don't know what'll happen.
We haven't seen any penalty assessments after 2015, and so
we don't know how fast they'll be doing those.
But the point is, if you have any nervousness or you've gotten letters about 2015, this is the time to look at your 2016 and 2017 reporting and make sure that any systemic reporting errors have been updated and corrected, or at least you know them, so that you're ready in case you get the letters.
Yeah, if you do nothing else, get a copy of your 1094C. Your 1094C, that's the summary form, right? And it's got a question that it basically is, are you going to get hit with the big penalty or not, right? And you have to check yes or no, right? So if you check yes, like it's actually the question's flipped. It's, did you meet the blah, blah threshold? Anyway, that question alone will tell you if you're going to get dinged for the big penalty. So go look at it. And if you don't understand what it means, call us.
Okay, this is a really quick slide. This is just a reminder that employers, you still owe the Pakora Fee for this very last year. This is the fee that goes towards studies on the effectiveness of various medical treatments. Transitional reinsurance fee was a big deal, but that is long gone. I will tell you, in that legislation, proposed legislation that I was just speaking about, there is yet another provision that would delay the Cadillac tax. I believe it's effective as it stands today in 2023, and the legislation would push it back yet another year. Association Health Plans.
You want me to do the background? Okay, so association health plans are a variety of, no, I don't need that. You need that. They're a variety of MIWA, multiple employer welfare arrangements. MIWAs exist when unrelated employers have the same health plan. Unrelated employers have the same health plan, not in the context of collective bargaining agreements and multi-employer plans. Okay, so we're going to set aside union issues. This is, like Venable and Arnold and Porter decided that they're going to have the same health plan. So long, long ago in the dark ages, the states regulated that. Then Congress passed ERISA in 1974, and ERISA said, okay, feds are occupying the field. We're going to regulate that. There were a lot of problems with that because the feds allowed there to be self-insured MIWAs, and what happened was there was no there, and a lot of these went belly up and had a lot of bills to pay, and the doctors didn't get paid, or the doctors sued the individuals because the plans had run out of money and didn't pay the bills. Complete nightmare, honestly, and I practiced then, and it was just awful. So what happened in 83 was that ERISA was amended to say that MIWAs could be regulated by the states. So great. That's where things stood for a long time. So most states, all states say that you can have a fully insured MIWA. Okay, it's fine to do fully insured MIWA. That's not where the risks are because the insurance company will definitely pay the benefits. About half the states allow you to have a self-insured MIWA. The other half prohibit self-insured MIWAs completely. The ones that permit it generally require the MIWA to meet the same financial requirements as an insurance company would have to meet, which makes it very unappealing because those requirements are, you got to have a lot of reserve. Some states have lower requirements, but as a rule of thumb, that's how it works. So we were in a universe where it was very difficult to have a self-insured MIWA. It was possible to have a fully insured MIWA. Excuse me. And the federal government had some guidance on the fully insured side that basically said, if you were fully insured, so if Venable and Arnold and Porter bought an insurance policy together, whether or not they got small group or large group pricing, okay, bad example because we're both large, but go with it. If we had small group or large group pricing, we were looked at individually for that purpose, right, rather than together. So if we had 30 people and they had 30 people, we would both have to buy small group policies.
And the importance of the small group policy, right, is that it has more bells and whistles on the coverage. So
more expensive.
It's more expensive. You have to make sure that all the essential health benefits are covered, meaning you have hospitalization coverage, RX, mental health, and it's community rated. So it's not rated on the experience of the group. It's based on the community, where the employer is, and you can only vary based on age and tobacco use. So more expensive coverage. There were ways to actually look at that group as a whole if certain bells and whistles were meant, but relatively rigorous rules. And as part of the Trump administration's executive order directing departments to decrease regulatory burden and to make more means of health insurance available, they proposed a rule to loosen up the formation of association health plans that was finalized in June of 2018. And it is easier to bundle these unrelated employer groups into a large group, so avoiding that community rating, avoiding the essential health benefits, and allowing, for the first time, sole proprietorships to actually be included in the association health plan. The effective dates are on the slide that I don't think we need to walk through. And as an employer market, there are some small employers that might find it attractive to join an association health plan. Large employers, I don't think that's very likely. And there's a lot of debate what this does for consumers in the marketplace. Does it provide more options, or does it erode the more robust coverage that you typically see? And in fact, there are 11 states plus DC, the AGs have actually filed suit to enjoin the regulations. Yeah, go.
Oops, sorry.
Maybe we should get to you have to point at it.
Okay, point at what? It's going the wrong way. Okay, get it going. There we go. That's it.
Yeah, so we should just say there are new regulations that talk about short-term, limited duration health insurance, and that's not our redundancy, that's the government's redundancy in the title of that insurance. But it's essentially gap coverage, and under the Affordable Care Act, it could be no longer than 3 months. You can now have that coverage last for 12 months and renew it for up to 36 months. And it doesn't meet all those bells and whistles of coverage in the individual market. So it can have pre-existing condition exclusions. It doesn't necessarily have to provide the essential health benefits. It can have caps on annual and lifetime maximum. So again, there's argument on both sides whether it's actually adding additional options for cheaper insurance in the marketplace or eroding protections to consumers who might not realize that they don't have cancer care or mental health coverage.
Yeah, this is individual coverage, so it's nothing that you're going to be able to offer to your employees, but it's something that your employees might want instead of COBRA. Or if you guys have a waiting period on your plans, it's something people might come to you with having this already. Was there a question? Sorry. Nope. Okay. It's not just me.
Go ahead. Do you want to take
No,
that one?
I just want to say that we're running a little behind, so let's just cook it along. No, go ahead.
Okay, so just an update on what the insurance market looks like, the exchange market, in fact. So we have 23 more insurers selling the plans in 2019. We have 29 insurers expanding coverage areas in 2019. We're seeing a drop in premiums. So we're exactly where the designers of the Affordable Care Act wanted us to be, which is just an interesting snapshot.
Okay, trends affecting health plans. I hope you've been reading about this one in the newspaper, because I sure have. Surprise medical bills.
Okay, so surprise medical bills. So by that, we mean out-of-network providers submitting claims. We see this often happen in the emergency room setting, or an ancillary physician, such as a radiologist or anesthesiologist submitting a bill. And the problem is, since they're out of network and the patient might not have known that, the plan pays whatever it pays, and then the provider balance bills the individual. And under the Affordable Care Act, what we saw was that if it was emergency care, then the plan had to pay this out-of-network provider exactly what it would have paid an in-network provider, but it permitted balance billing on the back end to the patient. So some states have adopted legislation that would say you can't balance bill the individual. But if you're in a large employer self-funded plan, the balance billing was still permitted. So there is draft legislation by 6 senators that would prohibit that balance billing on the back end on a federal basis, and it would provide protection for employees who are covered by a self-funded medical plan. And then as far as trends, we are seeing a lot of litigation closely related by these out-of-network providers, and they're being more aggressive. And what they are using as a weapon, really, is a request for the documents under which the plan is operated. And under ERISA, you've got 30 days to respond to that demand. They are also tacking on a provision under the claims procedures for all of the relevant documentation that was used in the initial denial. And they're also cleverly arguing that that demand is subject to that 30-day rule as well.
So the thing you really need to do here is you really need to have a system in place for when these letters come into your company, for them to get to you so you can get them to the right person. Okay, so what we are finding is we are getting, the providers or their law firms are sending these letters in to the plan administrator, which is, if you have a self-funded plan, that's the company, right? And it's going to the mailroom. And it's taking forever for that letter to get to the benefits department. As soon as it gets to benefits, they send it on to the lawyer. But that delay is a problem because after 30 days, penalties can start to accrue. Okay? So having a system for getting those letters to the right place so they can move through to the appropriate places quickly is really important. And those letters are getting, as Tora said, nastier. They're not mean nasty, but they're like lots of bold and big letters and underline, and they're asking for things and say, you will be violating ERISA and, you know,
and state law,
blah, 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 blah. So the letters are much more hysterical than they used to be. That's a better way to put it.
There are two, for the pharmaceutical industry, right, or for prescription drugs, there are two acts that were just passed. They're basically the same. They prohibit both in the commercial market and in the Medicare market. They prohibit the PBMs of the world, the pharmaceutical companies, from telling pharmacists that they cannot tell individuals that it may be cheaper for them to pay out of pocket than to use their insurance for the drug. And there's new proposed legislation that's supposed to come out, or proposed rules that are supposed to come out any day now from HHS that will require drug companies to post their list, or to list their prices in direct-to-consumer ads. We have a lot of questions and thoughts about what those prices are going to look like. There are all kinds of ways to price prescription drugs, and we're not sure what that's going to look like, but there is a push towards transparency and understanding pricing for pharmaceuticals.
I want to say one thing. One other trend that we're seeing is direct contracting, and if we have time, we'll come back to that. So if you have questions about that, bring it up in the question section.
Okay. Also, what we are seeing is a trend, and as a new vendor, a specialty vendor, is we're seeing what I would call the super TPA, third-party administrator, at the top of a self-funded medical plan. And there are companies that are offering navigation services to employees on how to use and access their health coverage. Health coverage is a confusing market, and I'm not telling stories out of school or whatever the phrase is. There's an article, a recent article, that Comcast is using one of these navigator companies, happens to be Accolade, and essentially you don't go to your TPA to ask questions about your medical coverage. You go to this super TPA at the very top, and you ask all questions, and you learn how to access your medical coverage. What specialty vendors are there? You look like you have something to say.
I have something to say to my assistant back there. My phone is locked, so I can't get questions. So you're going to have to write them down for me. Thanks. Sorry about that.
Let's just go on to medical apps to keep us rolling along.
Want me to go?
Yeah.
Okay, so do you have that percentage? The numbers, though, there's a lot. These are more and more popular. So these are apps like tracking your sleep, weight loss coaching.
For your employees. Accessible to your employees.
So the employer buys an app for any employee that wants one, so they can download it onto their phone. That's what we're talking about. And the app has some medical function, some vaguely medical function.
And the statistic that I ran across is the National Business Group on Health said that more than half their employers are offering these medical health apps to employees, and that more than 75% plan to do so in the next 3 years. And for people like us, they present all kinds of interesting regulatory questions.
Not all of which are on this slide. But one is, the first and most important one, is it a medical plan, right? There is no, so something is a medical plan if it provides diagnosis, treatment, payment for, or actually provides the diagnosis and treatment and medical care, okay? Trying to figure out whether these apps do that or not is kind of tricky. There's no guidance from the agencies, IRS, DOL, HHS, that regulate employee benefit plans. What we have done in the past is we've piggybacked off of guidance from the FDA, which regulates the medical apps themselves. So the FDA has a system which basically says, some of you are clearly doing medical stuff, like ones that keep track of your heart rate and send that to your doctor so that he can tell you if you have some disease, right? There are some that clearly don't, right? Just things that let you track your sleep, right? It doesn't matter. It's just a tracking function. And then there's a huge bunch that falls in the middle. So these are clearly health plans, these clearly are not, and then these are the ones that we have a question with. So if it's a health plan, then that has a lot of implications for ERISA. Do you need a plan document, et cetera? COBRA. It has implications for tax, right? If it's a health plan, it's probably tax favored. If it's not a health plan, it's probably a taxable benefit. Our clients hate it when we point that out to them. You also may have to comply with HIPAA if it's a health plan, right? If it's not a health plan, you still have two other issues, which are, is it asking questions about a disability? That is, your inability to perform a major life function, right? It might be, in which case you have an issue under the Americans with Disabilities Act because you're not allowed to ask disability-related questions of your employees. Okay? That's problem one. And problem two is, does the app ask anything about family medical history? Because if it does, you might have a GINA problem. Apparently, I'm just a... That's because my battery is dead.
That is not a Juliana issue.
Okay, so we're going to try that. Is that better? Is that better? No? Yes? No, it's okay. There it is. Oh, it is. Oh, your mic has...
It was live.
They told me it was live. Okay. Apparently, we're all just incompetent at technical matters, which is why we're lawyers. So don't call us for your IT problems. ERISA, we've got wired. Okay, we're going to do one more. We're really cutting into their time now. So other trends in specialty vendors?
Right, so maybe now you can all hear me for the first time. Sorry about that. I was told it was live. So we're seeing all kinds of special contracting arrangements with centers of excellence for cancer and other type of diseases, specialty networks dealing with fertility, and such. We see a continued trend, this isn't new, towards on-site and near-site medical clinics for employees. And then a very, very fun one is data warehouses. So employers sending all of their health plan data, all of their leave data, all kinds of employee data to a warehouse to run analytics and report back and help employers strategize about their benefit offerings.
The one I'm seeing the most is the specialty networks. The hot ones have been fertility networks lately. There are also transplant networks. There are also specialty cancer hospitals that will be carved out. There's, another trend.
Teledocs.
Yeah, telemedicine and teledocs. One interesting thing about telemedicine is that somewhere between 10 and 15% of employer plans cover telemedicine. Less than or about half of 1% of the enrollees are actually using it. So we expect that to we expect both of those numbers to go up, but right now a lot of people are paying for it and not a lot of people are using it, and it's a way to save money. So okay. Thank you for your patience.
Thank you all for coming out today. Lisa Tavares and I are going to talk about retirement plan issues, and we're going to talk about some regulatory issues as well as some trends. There isn't any sort of huge legislation or huge regulatory overhaul, but there's a lot of little things that together add up to things to be aware of if you're responsible for your organization's retirement plan.
It's like your remote at home.
There we go. Okay, so the first thing that we want to talk about is something which has actually gotten a fair amount of coverage in the popular press recently, which is the notion of a student loan repayment 401k match. And I put match in quotes because it's technically not a match. It's technically a non-matching contribution, but so explain what that means. 401k plans and as well 403b plans are subject to the rule that the only thing that can be conditioned on an employer contributing to the plan is a match. it would be unlawful for an employer to say to an employee, if you put money in the 401k plan, we'll give you extra paid time off, or if you don't put money in the 401k plan, we'll give you extra paid time off. The only thing that you're allowed to condition on an employee's participation in the 401k plan or a 403b plan is a match. So that has kind of confounded employers who've been thinking, gee, we have a lot of relatively early career people. We want to hire early career people. We want them to find our benefits valuable and our 401k plan valuable, but they don't have disposable income because they're burdened by student debt. There's certainly a lot of people that fall into that scenario. So one employer came up with a creative approach to integrating the employee's student loan repayments into their 401k plan and kind of creating sort of a pseudo match, and presented their plan to the IRS for a private letter ruling and received a favorable ruling. So a favorable ruling from the IRS is only directed to the specific plan. It's not like a regulation or a notice, but it shows you what they're thinking, and it's valuable for that reason. So let's talk about the ruling that they ruled on, and then we can talk about some practical issues that would come up for employers that are looking to add that sort of feature. So the basic structure was that an employee could either be on the matching contribution track, or they could be on the student loan repayment track, which we abbreviate here as SLR, student loan repayment. Participant can only receive one type of employer contribution for a pay period. So you go through the year, the employee either contributes to the plan or makes student loan repayments, or does both, but is signed up for the student loan repayment contribution option. You go through the plan year, and then at the end of the year, the employer looks at the employee's plan deferral history and student loan history and makes contributions that are effectively matching each, but not duplicative. So there's no cost to the employer if this is structured the way that it was set forth in the letter, because let's say you have a 3% match in your plan, you match dollar for dollar up to 3%. Well, you're either going to do that for employee contributions to the plan, or if somebody pays $100 toward their student loan, you'll make a $3 contribution to the plan. So but not duplicative, and that's really the benefit of this. Now, so what are the issues with this? We've looked at this for, yes.
So are you saying that on the payoff for the student loan is based off of 3% of your payment, 3% of your compensation?
Well, it would be 3% of your comp.
Right. So basically, the $100 payment could have $100 being paid in.
Yeah, I'm sorry. You're right. Yes.
Is the student loan repayment done by payroll deduction to the employer, and then it goes on to pay the loan?
So for those on the webinar, the question was whether the student loan repayment is done by payroll reduction. That's an excellent question, and that goes to one of the points here, which is I doubt it. I think at this point it probably wasn't, and there's probably a manual intervention that has to be done to actually tabulate what the student loan repayments were. So that is one of the early we put these down as early adopter practical considerations, because I do think that over the next couple of years, vendors will probably add this sort of provision to their form plans and to their record keeping systems, because it's of great interest to people. But today, vendors they're not integrated and set up for this, so there would be a manual process. And another consideration, which we've run into, which is a practical consideration, but a real one, is if you're using a vendor pre-approved plan document, which at this point most 401k plans, most 403b plans are using vendor documents, check the box sort of documents. Those simply don't. They certainly don't have a section for this, because this is brand new, and you can look at the document and see if you can get it to work, and you might be able to, but you might not. So those are two practical considerations on this. But this is definitely something that I think within a few years, I think we'll see a lot of plans doing this.
So we have a question here, which is there any specific amount of student loan repayment that you have to make to qualify for this?
No, it's really up to, it's really a matter of plan design. I think the concept would be that it would be parallel to your match. So if whatever your match rate was, you would choose a parallel rate for the student loan repayment.
And then there's one more question, which is, can you have the student loan match, the student loan repayment match? Can it be for some student loans and not others? Like, can you distinguish between undergrad and grad school loans, or med school loans and business school loans?
I don't think there's anything in the ruling that spoke to that. I would say that you probably could. I don't see why you couldn't. The issue of distinguishing is important because this contribution is subject to IRS non-discrimination requirements, which means that it has to be made to a non-discriminatory group, or at least available to a non-discriminatory group. But I don't, based on the ruling, I don't see why an employer couldn't say that it applies to one type of student loan repayment and not another. Shifting gears a little bit, I'm going to mention a few trends in fiduciary responsibility, fiduciary oversight of plans. First and foremost, it didn't include it on the slide because it's a little bit dated, but just to make sure everybody knows, the Labor Department fiduciary rule is gone, removed by a court, not repealed, but removed by a court. So it was kind of anticlimactic for those of us who followed it carefully. Everybody was running around like crazy trying to get ready for it, and then boom. So that is gone. But that said, vendors did change their approaches to things because of the rule, and some of those things are sticking. So some vendors are offering more investment advice services, and some vendors they've changed the way they interact with plans on issues like participant distributions and advice in that respect. So there are some benefits to it, and then the other thing, which I think is really a benefit, even though the rule's not around, is the plan sponsors are acutely aware, and that's the first bullet point here, of the need for that running a retirement plan is a serious fiduciary endeavor, and the need for plan internal governance is significant. Clients that we've worked with for a long time hopefully have internal committees set up and have a good oversight process and some liaison to the board so that the board is aware of issues that come up with the plan. But not all companies do, and that's something that we see continued focusing on. Another thing that we see focus on relates to, this is the second bullet point, is revenue sharing. Revenue sharing, simply put in the retirement context, is the notion that one of your you have a menu of investment funds. Those investment funds, depending on the type of fund and the share class of the fund, might be deducting money from the assets and returning some of that to the plan record keeper. So if you're with Vanguard or Fidelity, not to pick on any particular one, but if you're with one of those record keepers, that record keeper might be getting some money from the fund companies in your lineup. That's revenue sharing, and that's been around forever. That's nothing new. What has changed dramatically over time is that back in the day, there was a lot of revenue sharing, and it wasn't uncommon for plant vendors to pitch their services as essentially no cost. You use this fund menu, and that's it. There's no more cost involved. Those days are over. People are much more sensitive to the notion that revenue is being shared, and they're sensitive to the notion that there are in a standard fund lineup, there'll be some funds that share revenue at different rates. So there'll be, say, the XYZ growth fund might share a lot more revenue than an S&P 500 index fund. So if you don't manage the process, what you have is some participants who are paying for others. You have, participant A is invested in high revenue sharing funds, and participant B is not, and so A is subsidizing B. People are becoming sensitive to that there's a few ways that they're dealing with that. One way that they're dealing with that, if possible, is to go to zero revenue sharing funds or share classes, or so-called clean share classes. That's not always possible, either because a clean share class doesn't exist for your fund, or because they're due to some anomalies in pricing. You might actually end up better on a net basis if you use a fund that has some revenue sharing and you rebate it. So vendors have rolled out the notion of fee levelization, which means that if, to the extent you have funds in your menu that revenue share, that revenue sharing will either be fully rebated or partially rebated to participants. The participants who are in the revenue sharing funds will see a credit on their account. Everybody will kind of be equalized, and then they will be charged a fee which is proportionate based on their assets, so that you avoid the cross subsidy. Pretty complicated. If you've been involved in it, you probably know there's a number of different nuances to it. But if you haven't, it's something to look at, because if the process is left unmanaged, you probably do have some participants who are subsidizing others. A couple other things just to mention quickly: widespread adoption of robo-advisors due to the technology and probably the 9-year bull market. Robo-advisors have become very popular. These are advisors. A participant signs up. The computer program has their demographic information, gets some inputs, and manages their account. A few years, in the past, there was probably some hesitancy from a fiduciary perspective to do that. I've seen that hesitancy slip away, and I think most plans, or certainly bigger plans, do offer robo advice. And then finally, one other thing that I've seen, particularly in the mid-small size plan market, is the plan will have an outside investment advisor. The traditional model, they call it a co-fiduciary model. A committee running a plan will hire an investment advisor. The advisor will come in, advise the committee. The committee will make decisions based on the advice, but the advisor is not actually making the final decision. That's a co-fiduciary, or call it a 321, section 321 of ERISA fiduciary. I'm now seeing some plans that are saying, you know what, you guys are coming in and giving us the advice. Why don't you just make the decision and implement it, and we'll keep an eye on what you're doing, but we're going to outsource the decision to you. And in the small and medium-sized plan market, I do see that. Yes.
So our investment advisor is Repayment. It's a registered investment advisor. So, and he says that he is a fiduciary. So would he be the discretionary 338, or is that a question? Do I need to confirm that?
So the question is a plan sponsor has a registered investment advisor, whether that, and that would be a fiduciary, whether that would be a 321 non-discretionary fiduciary or a 338 discretionary. And the answer is you'd have to confirm it. It's a matter of contracts. You'd have to see what the contract says.
Undoubtedly, you pay more.
And you do pay more. You did pay more.
If you have a 338 advisor, does the investment committee still need to meet?
Yes, it does need to meet to keep an eye on it, because ultimately the committee is responsible for having that advisor and eventually maybe replacing them or monitoring them. But its duties are lessened. It's not in the minutia in the same way.
So is the biggest difference then is that the non-discretionary does not make the decisions. It leaves it to the committee to make the
Correct.
decisions. Whereas if it's a discretionary, they come in and they say, this is what we do.
Right. That's right. Yeah.
To answer the question.
I know we're running short on time, so I'll just spend a moment on each of the remaining items that I had to talk about. If you're, we're good on time.
Yeah.
We're good on time. Okay. So if you have a 403B plan, this is not for 401ks, but if you're a 501c3, a lot of 501c3s, or if you're a public school or university and you have a 403B plan, there is a new plan document update requirement, may be a little bit too strong, but strong suggestion. And the background here is that for many years, the IRS has, for 401k plans, they have pre-approved vendor documents. So Fidelity Vanguard has an adoption agreement. The IRS blessed that. When you sign up with Fidelity for your 401k plan, you're on a document that the IRS has blessed. As long as you check the boxes right, you're blessed. That has never existed for 403b plans until now. Now the IRS has, for the first time, has rolled out a similar program for 403b plans, and the vendors have, a few years ago submitted their form documents to the IRS, and most of them have gotten approved. Not all of them, but most of them have gotten approvals. And the vendors, the TIA-Crefts and Vanguards and Fidelities, are coming to their 403b clients and saying, hey, we have a new IRS-approved document here. You should update it. Now, if they update it by March 31st, 2020, then there's some retroactive reliance on the qualification of the document. So that March 31st, 2020 is effectively called a deadline. It's all sort of soft because you don't actually have to do it at all. If you don't want to, you could stay with an individually designed document. But most 403b plans are not that complicated and would fit on a pre-approved and would be well served by using one. I think the takeaway here is that if you have a 403b plan and you don't know what I'm talking about, contact your vendor because it's going to take some time. It takes a number of months to get. There's a questionnaire process and review, and documents get approved. A word about the IRS recently rolled out some new guidance for its plan correction program. Everybody with a plan is probably familiar with this. At one time or another, there's mistakes are made and corrections need to be made. There's a couple of avenues through the program. There's a lot of things can be handled through self-correction where you don't go to the IRS, but not everything. And there certainly are instances where plan sponsors have to do an IRS submission. Beginning next year, as of January 1st, that's going to be available to submit online, and then beginning April 1st of 2019, it's going to be mandatorily submitted online. There's not going to be an option to mail in those forms. So we'll all learn together as to how that works. But that's not a change really in the substance of the correction, but it's a big change in the process of how it's done. Two more minor points here. One of them is the 2017 tax law changed the impact of participants with 401k loans who default or can't pay those loans back when they terminate employment or when the plan terminates. So the scenario here is an employee has a loan outstanding, say it's the $10,000 balance, and terminates employment. And the plan says, okay, you got 60 days to pay us back, and they don't have the money. They can't pay it back. So that loan is going to go into default. It's going to be treated as a deemed distribution, and they'll get an IRS form saying that they received a distribution. Under the old law, the employee could have contributed that principal amount to an IRA within 60 days of that deemed distribution and avoided tax. Now there's a much more extended period, which is where are we? Where are we going? There we go. Okay. Yeah. So now the employee has until the end, the tax return deadline, filing deadline for the year after of the default. So if there's a default that happens, that wasn't supposed to happen.
Like I said.
Yeah. Technology and lawyers. So there's that extended period. And then finally, and this is really not, I don't think, too significant, but it is a change. If you've ever had to make a corrective contribution and with a so-called QNEC or QMAC, which is a vested employer contribution that you contribute either to satisfy a failed discrimination test or to in the IRS correction program, you can now use forfeitures for that. Yes.
On the forfeited loans, where you said basically 60 days is going away and it's going back to what the tax return is due.
Yeah.
Does extensions count?
Yeah, it's 60 days from the. I think it's including extensions. So it's
Okay, so let's say, so if someone defaulted today,
they would have
they
until
have the year from October.
Yeah.
Until next October.
Yeah, which is a big benefit for people. Yep.
I'm gonna try to set this timer. Let's see. Okay. Let me know if you can't hear me. Good afternoon.
There you are.
Oh, good. I put on the lanyard, so I think that's the difference, yes. Good afternoon. I'm going to now start to talk about some other legislative changes with respect to retirement plans, the first being hardship distribution changes. And the Bipartisan Budget Act of 2018, which was passed earlier this year, made changes that are effective next January, which is soon now, January 2019, with respect to hardships. We're awaiting specific guidance from the IRS on exactly how these changes are going to be implemented, but I'll talk generally about them. It's interesting because usually when new rules come into place, we start to hear from the record keepers earlier in the year, and we were just starting to hear from record keepers that they're trying to tackle these changes but not quite ready. And for our individually designed plans, I've sort of been suggesting to people that I was going to look to early November to make decisions, but I think until we get some specific guidance from the IRS, it doesn't necessarily make sense to update plans. Presumably there's going to be some sort of retroactive fix for the law with respect to any hardships that are effective beginning after January 1, 2019. So the first change was that Congress required an amendment to the hardship regulations to eliminate the 6-month suspension requirement. Keep in mind that with respect to the 6-month suspension that's put into place, it impacts other plans, which we sort of use these sessions as a reminder of the things we don't think about on a daily basis. So it actually impacts, it could impact a non-qualified plan and cafeteria plans where the suspension, the people are not supposed to be making contributions during that period also. So assuming those restrictions are actually in place, you have a process in 2019, presumably that's going to need to change if you decided you were going to remove the 6-month suspension. We believe, based upon the law, that removing the suspension is permissive, meaning you don't have to do it. I think for a lot of pre-approved plans, they'll probably automatically do it. The little we've seen from record keepers, it seems like they're going to have sort of an across-the-board rule. And as we go through the rules, I think some of the rules make a little more sense than other rules. So, so you may see it play out that way. Let's see. So the next change is with respect to what buckets of money, sometimes called sources by the various record keepers, can be used for hardship withdrawals. And, oh yeah, no, it was that slide. Yeah, sorry. I haven't moved on to substantiation yet, but you can leave it there. So plans can permit hardships to come from elective deferrals as well as employer matching contributions and employer discretionary contributions. The law was changed so that hardships may also now be made from qualified non-elective contributions and qualified matching contributions, which we commonly refer to as QNEX and QMEX. Typically, those amounts are going to be from amounts that are part of some correction. Not all plans provide for those types of sources, but it could up the amount, presumably, that someone has available for a hardship. In particular, I think earnings on elective deferrals is really going to be the bucket of money that's more available to people realistically. The next law change is with respect to the requirement that a participant has to obtain a plan loan before the hardship withdrawal can be granted. Previously, you needed to first request a loan and prove that you couldn't get some other sort of distribution. Presumably, the IRS is going to clarify whether the rule actually applies to all distributions. The law specifically refers only to the plan loan. So I think it's sort of halfway there maybe, and I can't imagine why we would only have sort of a half of a restriction removed, and that may have just been a technical issue in terms of drafting legislation. So we're taking a wait-and-see approach on that. One issue we should point out is it's unclear whether the rule is, these rules are specifically applicable to 403B plans. We think, like most other 401k elements that are common, it should apply to 403B plans, but the legislation specifically refers to 401k. It refers to creating a new section of 401k. So again, that may be a drafting error, which we assume that maybe not in the same guidance, but in some guidance, the IRS will clarify what the intent is. So now we can talk about, with respect to substantiation. So the IRS issued guidance about hardships, which is now only so valuable because we've had these changes in the law, but it is instructive. And it came out in the form of, they issue these snapshots now and these summaries of exam positions that they have. Going back to sort of the basics, Rule 1 with respect to hardships is you have to have an immediate and heavy financial need. You may be familiar with the fact that there's a safe harbor where if you meet one of these 6 categories, you're deemed to have satisfied the requirements for a hardship, and many plans have done that to avoid having to deal with some of these substantiation requirements. But I think one thing that was interesting that came out of again, sort of going back to basics and reminding ourselves about the details of when these issue snapshots were issued last year was that this is what the examiners are looking for. The second rule, general rule with respect to hardships, is that the hardship distribution has to be limited to the amount that's necessary to satisfy the need. So I think all of that's fine, but in the real 401k world, it's all done electronically, right? And hopefully you have little to do with it. So you're relying upon your record keeper to follow the rules and get all the information. But the IRS, in terms of what they're telling their examiners, and I don't think all of this is going to change given the change in the law, is telling them they need to get substantiation. In this issue memorandum, they talked about the fact that the employee can self-certify as to why they need the money, but you still need to have the documentation to back up the amount. One of the concessions in IRS recognizing that many plans are using electronic hardship was that you can have this sort of summary notice. Presumably it's what pops up when your employee applies for a hardship. I don't think anyone has hardship forms anymore, but they may. But presumably it's a notice that pops up when they do the online request, and it goes through and it says you have to have substantiation. Presumably has some examples. You know, if it's for eviction, you have to show the eviction notice or whatever the requirement is. The key, though, in that examination guideline is the plan sponsor is still responsible if there's an IRS audit. So while we understand that, it's for simplicity that we're relying upon the record keepers, the issue is that we have to have a mechanism for plans to actually be letting participants know. And so I've started adding to SPDs in addition to whatever's on that page of whichever website to make a statement to let participants know they need to keep that substantiation because that could be requested in the IRS audit. So is it up or down? Down. Okay. The second issue I'm going to talk about with respect to IRS guidance that came out is related to multiple participant loans. This is a little dense. I don't know if it's more dense than the others, but the IRS clarified what seems like it should be relatively simple, right? There's generally a $50,000 limit we think of. But the IRS detailed in this issue's spotlight that they wanted to clarify that if you have more than one plan, multiple loans cannot exceed the lesser of $50,000 that's reduced by the difference between the highest outstanding plan loan for the 1 year period before you take a new loan and the outstanding balance of plan loans on the date in which a loan was made. So I'm going to give you an example.
There will be a test.
Yes. I'm going to give you an example. Or the greater of the $50,000 or $10,000, or 50%, I'm sorry, of the account balance, or $10,000. So if someone if someone is requesting a loan and 50% of their loan balance is less, or I'm sorry, their account balance is less than $10,000, they can still take out a $10,000 loan. But to try to simplify it, in an example, which is in this issue guideline, if participant Mark had an account balance of $200,000 and he took out a $40,000 loan in 2015, and he now wants to take out another loan as of October 1st, 2018, he's only going to be able to take out an $18,000 loan. So going through these little facts, on October 1st, 2018, you have to go back and look at the loan balance as of October 2017 to determine what the amount is. And then it gets a little more intricate. So
Lisa,
call one of us if you want to discuss it.
Is this rule something you expect the vendors to be handling, or is this something you expect lawyers to be handling?
Well, yes, I certainly expect vendors to be handling it, but I have learned with clients the hard way that it wasn't being done that way. So we have more than one client that has multiple plans. Because this seems really simple, right? How hard could it be? But I am currently advising a client where it is our understanding that there's a systemic problem with a large record keeper who's going into the IRS, like a very large record keeper, because they've made this mistake internally. So, we're now trying to figure out how to correct people's loans, and people are out, people got money and they need to pay it back, and the employer doesn't want to pay it back, so it's problematic.
And it is
the effective date of, this is guidance that came out where they're clarifying. So this is the same, this $50,000 rule and the 50% has always been the rule. The IRS has just clarified, I believe, because they see a lot of non-compliance during audit.
So the 1 year look back has been in the law for a while?
Yeah, I don't think that's new. I just think, again, it's a detail we're not focused on at the level, right? Because things have been simplified with all of this sort of online services that are out there. So we've started, I think, talking, the rule came out, this guidance came out, I think this one earlier in the year or late last year. So we've just been, for plans that I know have multiple, particularly have multiple plans where it's more likely to be a problem, I would think. I would hope that this isn't as big of a problem if you have one plan. But again, if there's a systemic error with respect to one record keeper and they didn't get it right, it's possible that others couldn't. So I would assume the auditors are looking at this issue, but it's worth, I think, in whatever communication you have with record keepers as to how they're managing those multiple loans. Next, I'm sorry.
How would they look at multiple record keepers? So if you've got multiple different employers,
Oh, well, not different. No, I don't think it's. I'm sorry. How would they look at loans with different record keepers? You meaning if I terminated from one employer? Right. Good question. I don't know how easy it would be. I assume that's like the rule that when you go to a new employer, you have to keep track of how much you deferred earlier in the year. That's not having another employer plan outside of your current employer is not covered in that guidance. So I can't say it doesn't apply, but I think this rule is specifically related to your current employer and in this because it refers to the same control group. So next is the PBGC Missing Participant Program. This is a new program. The PBGC has had a Missing Participant Program for defined benefit participants for a number of years. Legislation enacted a new program for defined contribution plans, and it's taken some time for that program to get together. The thing that's and it's voluntary. Plans don't need to use the PBGC program. But the thing that's interesting about it is there's a one-time administrative fee of $35. So if you have a terminated plan, which might be related to an acquisition, we spend a lot of time helping people work through offloading those participants out of a plan that was hopefully terminated before the close of your acquisition. And we have started to end up using these private companies to take those assets, so we don't have 5,500 and other obligations with respect to plans. So this is another solution. And aside from working through the details, it's a little tedious. There's a whole set of regulations. Again, this seems very basic, right? There's a whole big set of regulations on how you actually get money from point A to point B in order for that money to avoid taxation. You're basically offloading that money to the PBGC, which interestingly enough, has created this directory. It's essentially a unified claim service. So you wouldn't be just relying upon a sheet to whichever state that you're in. With the sort of mobile economy we have, that's probably, from a fiduciary perspective, something you may want to consider, using this now national repository versus X states unclaimed property versus Y state, and employees could go anywhere, and it's kind of hard for them to figure that out. I also think that the $35 fee makes it compelling, and that it's certainly the PBGC program for a terminated plan should be considered in conjunction with review of any of the other private companies, because at least the ones that I've seen, they all charge some sort of maintenance fee. Next, we'll talk briefly about financial wellness. Let's switch back to you, Harry. It's going the wrong way. Okay, there you go, sorry. I don't know why it's so difficult. So a number of employers are responding to the stress that employees are feeling regarding the difficulty in saving money for retirement, saving for kids going to college, and other stressors. Some employers are certainly more proactive than others. There are various tools that we see. Again, we see apps, a lot of apps that employers are investing money on and bringing available. There are a number of vendors who provide different services, sort of like what we see more in the health space, where they'll come in and talk to employees either in a large group or on an individual basis about budgeting and savings mechanisms. And we've seen a number of the large record keepers over the last few years, including lifetime income type of tools in their platform. So you can see your retirement account balance, and if I input either from another tool that I have, like Quicken or something, or I put in my own information, I can see what my projections are for Social Security and other assets that I have. And the level of education surrounding that, I think, is useful for employers, and at least I think makes most employers feel like they're fulfilling their fiduciary duty to educate people about retirement plans. The reason we wanted to bring it up here is we were more concerned when the fiduciary rule was sort of floating out there about how financial wellness worked. Particularly, at least Harry and I are dealing with wellness on the side, that people are trying to do things in qualified plans, which is a little different than the other wellness that we deal with. And we were concerned about sort of how much you could do with respect to a qualified plan. It's the same issue about, is it really something that's covered by ERISA or not? So I think most of the vendors we see are something that should not be covered by ERISA. We want to keep things out of ERISA. But I think it's important to be mindful and pay attention to how these different vendors, apps, or other programs are integrated into your existing benefit system. But a best practice probably is to look at these vendors in the same way you would any other vendor that you're picking up for benefits, and evaluate them and do your homework. Next, we're going to move to cybersecurity. And Tori, do you want to talk about basic safeguards?
Sure. So I will kick us off. breaches everywhere. It's in the newspaper every day. Yesterday, we saw that Anthem has agreed to pay the Office for Civil Rights within the Department of Health and Human Services for a 2015 breach, $16 million. It affected 79 million Americans. We've been through the Equifax breach. Those were data security issues, not directly at an employer site, but an employer vendor. We've seen it outside of, obviously Equifax was outside the healthcare industry. Also, there have been articles about a provider with false credentials that was getting access to employers' employees, PII, so not only data security, but fraud, and getting access where there should not be access to employee data. And so the importance of vendor management and doing due diligence on their privacy and security programs is really very, very important. But before we talk a little bit about that relationship, the IRS gave some soft guidance with its Security Summit partners to employers focused on employer systems and how they safeguard their employees' PII. And that's listed on that slide. I don't pretend to be a security expert, but these are very basic. Have a written data security plan for your employees' PII, encrypt it, keep it secure when it's at rest. I'm going backwards. Make sure you have a backup of it that is equally as secure. Two-factor authentication, so you need two forms to make sure the access is actually appropriate access. Have firewalls so that once you're in the system, you can't see all that PII. You at least have a firewall, a break with that PII, and make sure that you're updating and patching your software. Did you want to?
Yes. I want to talk a little bit more about beyond the basics of what we talked about is the basic criteria of what you need to do for cybersecurity. But the DOL came out a couple of years ago. We don't have a rule or a regulation, but they came out through this sort of advisory board that they had and acknowledged that cybersecurity and protecting participant assets is a fiduciary responsibility, as well as participant information. So it's not just PHI, it's PII, the personally identifiable information that's a big issue now. And with respect to retirement plans, primarily, obviously, it's PII. And when you think about it, everything you do in a retirement plan, everyone generally, I think, has to authenticate the first time through their Social Security number, and then maybe they switch it. Although we've been working on a forensic audit for a benefits client recently with a very large participant pool and determined that there was no second authentication. People were going and using their Social Security numbers every single time. And it's part of a cybersecurity breach analysis that we're doing where the insurance company is paid for this forensic auditor to come in and now identify pitfalls that exist in the benefit system. And so you don't want to be in the position of having to determine whether or not you really have to notify participants about information. We've also have a bunch of horror stories that we can tell you about different instances. We've seen problems with single sign-on, which I know people really like. But if you read...
So what do you mean by that? So going to your benefits portal and being able to see all your suite?
Right from our internet space and going in. I've seen it in the 401k space. And when you look really closely at the contracts with the record keepers, which I'm going to let you talk, I guess, more about, you're not going to be covered there. And you have very little control. The thing you want to think about with respect to these breaches is how best to manage that process if information has to be disseminated. I think people have experience with these little PHI incidents, but the experiences that I have with 401k plans tend to be systemic errors. It's rarely one person. We've seen where people have gone in and taken passwords. They've changed them, these cyber thieves, whoever they are, and then they wait a little while and they start taking loans or other forms of distribution. So they don't just go in and take accounts anymore. They become very thrifty. you know, those little things that come from your record keeper in the white envelope and just your name, you have to open them because they tell you someone changed your password. And people don't open them. The other big vulnerability, two of them that we've learned about, is your participants that have not actively gone in and created a special password for themselves are very vulnerable. It used to only be the disgruntled spouse or the bad child who used to get people's information, and we had, you know, that would happen every once in a while, and what do you do? But this money's not FDIC insured, so, you know, there's great risk, and eventually these record keepers are not, there's going to be a breach that's big enough, these record keepers are not going to be covering it. Our clients have been very fortunate so far that things have been covered. But
so you need to check your cyber insurance, right? Employers should look at their cyber insurance. They should be doing due diligence on their vendors. They should be putting security addendums on all contracts. So, right, it's way beyond the BAA. And with the BAA, you can have behind it, this is the basic security that we expect you to have. And then on the PII side, the retirement side, a full-fledged, looking a lot like a business associate agreement, and that you do have a notice obligation to tell us, and we do expect you to cover. Good luck negotiating caps on how much they should cover, but really sitting down and having a conversation with them about how they're protecting and what they will do, what notice they'll give you, and what they will pay for in case of a breach.
We spend a lot of time doing this, and you know, it's uncharted territory, but it's very important because you don't want to be the employer who all the money walked away somehow.
Okay, we've gotten a couple questions.
Sure.
So I'm going to punch those at two for Harry about the student loans. One is, the first question was, does the student loan repayment match only apply if the individual, the employee, is repaying their own loan? And the question makes a good point, which is there are plenty of parents that are repaying their children's student loans. So if I'm repaying my kid's student loan, can I get the match?
That's a fascinating question, and the ruling doesn't address it. But I don't. Based on the rationale in the ruling, I would think that it could work.
Yeah, in conversations off the record with the IRS, I think we've clarified that ruling is very specific to that employer, and that arrangement is not limited to what they presented. Right.
The somewhat related question was, are there any regulatory, and I would think they mean privacy, issues with collecting information about student loans?
Good question.
I'd have to check with one of our privacy.
Yeah.
Okay.
Good question.
That's a good question.
A question for Tora, which is, are concierge doctor fees deductible? Oh, she's shaking her head and she doesn't know. So
largely, it depends on what concierge services you're talking about, but largely no.
Right. The thing is, it depends. We always say that, and in this case, it's actually true. So, if the concierge fee, so first of all, if it's a health plan, then it's tax deductible, but you don't want it to be a health plan, right? So, if you don't want it to be a health plan, then you probably ought not to be deducting it. So there's a little flip side there, right? Because if it's a health plan and you're only paying the concierge fees for your executives, then you've got a discriminatory health plan. That's problematic. So there's a lot. And by the way, tax deductibility and whether or not you have a plan are two different questions. So it's super complicated. But
that's why I was shaking my head.
That's why she was shaking her head. But there are some fees that there's a good argument that they are not deductible and not a health plan because all they're doing is providing access. Right? So if I pay an extra $200 to One Medical, all that's doing is making sure I can get an appointment. It's not actually providing me with care. That's the argument. Has that argument been vetted by the IRS? No, it has not. I haven't seen any court cases either. So we're in a somewhat gray area, kind of like with the apps. So those are the. I'm keeping my eye on these. Oh, we got a new question. But in the room, do we have any questions in the room? Come
on. Okay, Harry, I think you answered this, but it's an oldie but a goodie because it's come up a couple times. Does the hardship distribution changes apply to the 403B plans as well? Oh, it was Lisa.
Yeah. We addressed that. We think that they should apply, but it's not clear because the actual law that was passed only refers to 401k. So hoping that we'll have guidance before the end of the year, maybe.
Okay, I wanted to say 2 words about direct contracting because that was a trend that we didn't really get to. My notes. So direct contracting is when an employer goes directly and makes an arrangement with a provider. So the first sort of big one of these was when Walmart made an arrangement with the Mayo Clinic so that anyone who was, I was going to say convicted, diagnosed with cancer would get sent to the Mayo Clinic. I don't know the specifics of the Walmart deal, but this is happening more and more with it's a flat rate, okay? And the flat rate will usually cover a specific service for a specific period of time. So a hip replacement and any related care for 90 days would be an example, right? Others, bariatric surgery has been another one, a number of specific surgeries. There's a spine surgery one, things like that. So there's a couple of issues. The main one, of course, is money, right? It's not at all clear. People are doing this so that they will save money. It's clear that in some cases they are saving money. It's also clear that it takes a little while, right? You're not going to show a savings right away. It's going to take time for it to work its way through the system. The other issue is a question. It's really an issue for the providers, but I think the employers need a heads up about it, which is this arrangement may turn the provider into an insurance company, okay? Because the provider is now taking financial risk. So you're saying, I'm going to pay you $90 to perform this, right? Well, if it ends up costing you $500, the provider's taken on that risk. So does that risk make the provider an insurance company under state insurance law? So that, like I said, that's not something that's a direct problem for the employer, but it may be a problem down the road, especially as the providers try to protect themselves from that. Questions on that? We're seeing that crop up. I'm hearing about it more than I'm actually seeing it. So there's a lot of blather about it, but sort of on the ground, sure, Walmart, maybe some others, but, you know, not too many of our clients. Other questions? We got anything? I think we did the ones from the.
Right on time.
Well, thank you very much. We're going to be here for a little bit if you want to come up and ask us questions. Thanks to everybody who tuned into the webinar. And I guess we'll see you soon.
Enjoy the afternoon.